Hello and welcome to today's Ground Report. One of the most high-profile editors and a celebrated author, Tarun Tejpal, who edited the very powerful and well-known Tehelka magazine, now faces 10 years of imprisonment, convicted by the High Court of Bombay at Goa on charges of raping his junior colleague during a company event in a hotel resort in Goa in 2013. This is one of the most high-profile cases ever in the history of media in Goa, and ironically, this is a media trial of a different sort, where a major media owner and editor was on trial. He got acquitted by the trial court, and then the High Court finally overturned that acquittal and has now decided that he's going to be in prison, serving a prison sentence of 10 years, albeit the fact that Tarun Tejpal has got 4 weeks to surrender himself, during which time he will also go to the Supreme Court and seek an appeal. While the details of this case will be heard and we will be discussing it, it's all over the media, but we will go into matters beyond just this decision by the court. However, let's now look at and begin with what really did the High Court say in the Tarun Tejpal appeal, which led to the final conviction order against him. The division bench of Justices Neela Gokhale and Amit Jamsandekar, Justices Neela Gokhale and Amit Jamsandekar, they set aside the acquittal and convicted Tarun Tejpal under sections 376(2)F, 376(2)K, 354A and 354B of the earlier IPC, because when the trial started, the earlier IPC and not the BNS was in place. He has been sentenced rather to 10 years rigorous imprisonment and granted 4 weeks to surrender. It was earlier 2 weeks, but later it was revised to 4 weeks. During this entire appeal, the High Court bench expressed anguish over the objectionable questioning of the survivor, his own colleague, and scrutinized the trial court's reliance on stereotype expectations of the victim's behavior. Now, the overturning of this 2021 acquittal by the Sessions Court in Goa, in Mapsa, in one of India's most watched sexual assault prosecutions, is significant because the conviction is related also to a man committing rape when he is in a position of dominance over the victim. It also relates, obviously here in this case, to the victim who was his junior colleague inside a hotel elevator, as I mentioned earlier, during the ThinkFest event, a very popular event conducted by the Tehelka magazine during those days, where thought leaders from all over the country and the world, top actors, top philosophers, writers, they all used to attend the Think Festival. So let's go back to when it happened and in what circumstances it did. Of course, Tarun Tejpal has said that he's going to challenge this before the Supreme Court. Now, let us look and go back to the timeline of the Tarun Tejpal case. And you'll see the graphics come up on your screen as well. In November 2013, during the ThinkFest, this alleged sexual assault happened in the elevator of a 5-star hotel in Goa during the ThinkFest event. In May 2021, the Sessions Court in Mapsa acquitted Tarun Tejpal of all charges against him. In the same year, the Goa government filed an appeal before the Bombay High Court, the Goa bench. And between June and July of 2026, the final hearings happened before the division bench. And on the 6th of August, which is the day on which we are recording today, the Bombay High Court had reversed the acquittal and convicted Tarun Tejpal. Now, when the trial court had acquitted him in 2021, they held that the prosecution had not proven the charges beyond reasonable doubt. And these were the grounds on which the trial court had acquitted him in 2021. So why did the trial court acquit him in 2021? That is what we are asking, and we are answering. The principal grounds on which the Sessions Court gave Tarun Tejpal the benefit of the doubt were contradictions and improvements in the complainant's account concerning the lift incidents, meaning that there were contradictions in the complainant's account regarding the lift incidents. CCTV footage, messages, emails, and her conduct after the alleged assault were treated as inconsistent with the prosecution narrative. Then, number 3, absence of medical or forensic corroboration. Number 4, Tejpal's apology emails to the victim were not accepted as unambiguous confession. Number 5, serious administrative lapses were recorded, including the failure to preserve or produce crucial CCTV and electronic evidence. The judgment on what became controversial later, the trial court judgment, said that the complainant had not displayed the quote-unquote normative behavior expected from a sexual assault victim. This approach was widely criticized as stereotypical victim blaming. Next, let's go to Advocate General Devidas Pangam. He scrutinized the trial court order, commented on it, and then laid the grounds on which the challenge was mounted in the High Court to secure Tejpal's conviction.
Trial court had completely ignored. On the contrary, the entire tenor of the judgment, which runs into more than 500 pages, the trial court attempts to sort of find out the conduct of an ideal rape victim. That ideal rape victim should have behaved in a particular manner subsequent to the rape. That was one thing in the direction in which the court went. Second most important thing is the trial court went into the character of the victim, which is impermissible in law. And because of the past, some sort of a conduct or character, the trial court says that there might have been some sort of a consent under which this happened. Now that was something which was really shocking. Absolutely there was no case of consent or anything. And on that basis, the trial court said that I am acquitting.
So the sentencing was announced a little before 2:30 in the afternoon. And let's hear what the public prosecutor, followed by Sunita Sawant, who is the IO in the case, had to say about it.
So he's been convicted for all the offences that he was charged for, and he has been sentenced to 10 years reverse imprisonment and a fine of 5 lakhs. That is the maximum that it has to be done concurrently.
Okay. We are seeing that all the investigation is carried out speedily, efficiently, and the evidences are placed before the court through the charge sheet.
Okay.
Yeah, we will ensure that justice is given to the victim.
After the judgment, senior Supreme Court lawyer Swapnil Kothari, in an interview to India Today, examined the trial court judgment as well and reacted to the High Court order convicting former Tehelka editor Tarun Tejpal. This audio is from the interview given to India Today, and we are playing it out.
What I'm glad about is that the justice has finally met. Now the only thing that remains is that I hope that for the 2 weeks or 3 weeks that the stay has been asked for, stay of the judgment by the defense lawyers, that until the appeal is filed in the Supreme Court, it's not given, and Mr. Tejpal does go behind bars. Because even if you promise to say that we'll file the appeal within 2 weeks before the Supreme Court, which is the right of any accused to ask for a stay, okay, fine, I'll file an appeal within 2 weeks. But thereafter, given the heavy roster of the Supreme Court, where is the matter eventually going to be heard? So what, until he's going to be a free man? What nonsense. So that's not going to work. Then that's no justice. Then this whole exercise of going into appeal and hearing the appeal and passing this judgment was an entire farcical exercise.
Incidentally, Tarun Tejpal, on a day that will obviously change his entire life, he seemed seemingly unfazed. He first spoke after the judgment, but before his sentencing.
अभी तो दोपहर को जज अभी बताएगा, अभी जब हम सुन लेंगे उसके बाद हम सुप्रीम कोर्ट जाएंगे, 100% जाएंगे, हमको कोई डाउट नहीं है। हम 13 साल से एक पॉलिटिकल वेंडाटा के पीछे, तहलका के काम की वजह से मेरे पीछे पड़े हुए हैं। तो हम लोगों ने इस ट्रायल कोर्ट में 7.5 साल पूरा केस लड़के हम लोग अक्विट हुए। अभी ये लोग फिर पीछे पड़ गए हैं। जो इनके साथ लोग हैं उनको तो ये सब अक्विट कर देते हैं। जिन्होंने इनके अगेंस्ट कभी भी पत्रकारिता की हो या कुछ भी कहा हो, ये उनके पीछे पड़े रहते हैं। आप लोग पत्रकार हैं, जाके देखिए पिछले 12 साल में कितना लोग को ये लोग गलत केस में फंसाया है। मेरे को भी इसी में फंसा रखा है, हमको फिर भी एक्विटल मिल गया उसके बावजूद। अब ये तो जर्नलिस्ट पे डिपेंड करता है ना कि वो जाके क्वेश्चन पूछे, सवाल पूछें। आपको पता है उमर खालिद जेल में बैठा है 6 साल से, आपको पता है शर्जील इमाम बैठा है, आपको पता है सुरेंद्र गैडलिंग बैठा है जेल में अलग अलग केसों में। भाई इतने नहीं है, कई दर्जनों लोग हैं। तो मैं भी उनमें से एक हूँ। ये बात सही है, तहलका ने पत्रकारिता की और कुछ ऐसी पत्रकारिता भी की जिससे वेस्टेड इंटरेस्ट, पॉलिटिकल इंटरेस्ट को कोई नुकसान होगा। अब उसके पीछे ये लोग बदला लेने के भाव से 13 साल से हमारे पीछे पड़े हैं। इन्होंने मेरी पत्रकारिता बंद करा दी, इन्होंने तहलका बंद करा दिया, इन्होंने मेरी किताबों का छपना बंद करा दिया। लेकिन हम लड़ेंगे। मेरे को पूरा फेथ है कि इतनी बड़ी जुडिशरी में ऐसे जज हैं जो सच देखेंगे और सच एकदम से सामने आएगा। एक बार आ चुका है ट्रायल कोर्ट में, जिसने 1.5 साल मेरा ट्रायल चला, डे ऑन डे, क्योंकि वो ऑर्डर डे ऑन डे का ट्रायल था। और इतना मटीरियल है, अगर आप लोग मेरे से बात करना बंद करें और जाके कोर्ट में एविडेंस देखें, इतना एविडेंस है कि मेरे को 10 बार बरी हो जाना चाहिए, एक बार भी नहीं। वो एविडेंस हम पूरा पब्लिक के सामने लेके आएंगे।
Now, after his sentencing, he appeared a little phased, but still remained very defiant, accusing the government of vendetta. Let's hear now what he told reporters after the sentencing was announced.
We are going to appeal against it. We are very disappointed. We believe the evidence in the case has not been appreciated. We believe there is enough evidence to very, very clearly exonerate me, not once, not twice, but 10 times over. मैंने जज को बोला, आप लोग जो कोर्ट में थे आपने सुना होगा, मैंने बोला मैं एक पॉलिटिकल विक्टिम हूँ।
पॉलिटिकली मोटिवेटेड है कह रहे हैं आप सर?
100%।
So do you align with Umar Khan's ideology?
Now, the AG Devidas Pangam has clearly indicated that the state would pursue rigorously this case in the Supreme Court as well against Tarun Tejpal's appeal, and is keeping their options open on pressing for maximum punishments in the section that he's been convicted in. And when you say maximum punishment, it means life imprisonment.
See, they are bound to challenge it. We know about it and we are all prepared for it. Our team of lawyers are there. We will defend it at any cost, and we will not let it lose in this manner. Actually, the time has been granted of 4 weeks now, although it was announced as 2 weeks. But I was just called, and the lawyer for the accused was also called in the chamber, and the judges have told us that he will get the time of 4 weeks to surrender.
सर तुम्ही चॅलेंज करतली ऑर्डर एनहान्समेंट ऑफ
अजून मेरेन आमी काय डिसायड करूंक ना, पण आमी आतां स्टडी करतले आनी ताच्या फुडें डिसायड करतले. आमी मॅक्झिमम सेंटेन्स मागिल्ले, 10 वर्सां सेंटेन्स दिला, रिगरस इम्प्रिजनमेंट दिला ताका 10 वर्साचो, प्लस फायन मारल्या. आतां ही जी फायन दिल्या पळय ती 5 लाख रुपया ती फायन विक्टिमांक दिवपाक लायल्या, आनी आमकां खरें बरें दिसता की ती विक्टिमांक कितें तरी कॉम्पेन्सेशन मेळटा.
I also reached out to one of the sharpest legal minds in Goa, Advocate Radharao Gracias, on the circumstances in which the High Court overturns a trial court verdict, and how the Supreme Court then looks at the case when it hears the appeal against the High Court order.
See, normally on facts, the interpretation of facts by the trial court at the initial stage is not generally upset unless the High Court or the appellate court has got very strong reasons to do so. Now, in this case, there is a finding of the trial court on facts. law, let us ignore the law for the time being. But looks like the Supreme Court has not, the High Court has certainly not accepted the interpretation of facts or interpretation of the evidence, the assessment of the evidence, the evaluation of the evidence done by the trial court, by the trial session judge, Shama Joshi. This is not a special leave petition. Under section 379 of the old CRPC under which this trial was conducted, an appeal to the Supreme Court is provided. Now, normally, in an appeal, the court goes through the entire evidence and the entire case can be fully reheard and redetermined. Now, in this case, particularly what happens is there are no concurrent findings of both the courts. In other words, the High Court has set aside the finding of the trial court. So they are entirely taken different views. So in such a case, the Supreme Court may hear the whole matter again and pass an judgment on the basis of its own appreciation of the evidence.
So what you're saying is very important, Advocate Radharao, that the court may re-examine the entire evidence and reinterpret it accordingly.
Yes. That possibility is there, quite high possibility, because this is an appeal. And in an appeal, of course, this is a second appeal, but practically first appeal for the accused. So in this case, and since it is a matter of life and a long sentence, I would expect the Supreme Court to thoroughly go into the evidence again and give a finding.
And as Radharao Gracias very importantly says, that the Supreme Court might interpret the case from the beginning, including reinterpreting the entire evidence which was presented in the trial court. Now, while the focus will be on Tarun Tejpal's conviction, his appeal, and when he needs to surrender, all of this will be played out in the media. But the questions that arise from the trial court order and now the High Court order are very, very significant, and they need to be understood beyond the immediate news developments that took place today. And we would like to point out towards that, even our graphics will give you the main points. Firstly, can the survivor's lifestyle used to judge the credibility of her complaint? That's point number one. And that became the central legal issue in this case. The trial court examined her previous sexual history, her drinking, her smoking, her personal relationships, her late night meetings, and her WhatsApp chats. The question that is being asked is, can the court use this to examine a central legal issue of rape and sexual assault? The appeal argued that all this, looking at these parameters, violated settled principles that consent must be assessed in relation to the incident itself and not by references to stereotypes or moral judgments. Next came the question, does quote-unquote normal behavior after an assault exist? Now, the trial court inferred that because the complainant continued to interact with the accused Tarun Tejpal, attended events and communicated with others, she could not have been traumatized. The appeal challenged this, arguing that the courts cannot prescribe a single expected behavioral pattern for survivors of sexual assault. The next question that was argued is, can the conviction rest substantially on the testimony of the complainant? Indian law recognizes that a conviction for rape can be based on the sole testimony of the prosecutrix, meaning the survivor, if it is found credible and trustworthy. This is what the Indian law recognizes. A key issue, therefore, was whether the complainant's testimony remained reliable despite the inconsistencies highlighted by the defense. And this issue was discussed during the appeal in the High Court, and the High Court came to the final conclusion, and we assume it because we've not gone through the entire order yet, that the complainant's testimony remained liable, which the trial court did not agree to. Another question that came to mind during trial, or was discussed during trial rather, how should electronic evidence be interpreted? The defense relied heavily on emails, WhatsApp chats, subsequent communications and photographs. The prosecution argued that these were selectively interpreted and did not amount to consent. That is what the prosecution argued, that there was no evidence of any consent by the victim towards the accused. The next issue that was looked at, and when we are talking of consent, the next issue that was looked at during trial, of course, and then during the appeal, what constitutes consent in a confined space? Now, the allegations concern two incidents in an elevator. And these legal issues revolved around whether there was physical resistance, whether there was coercion, whether there was abuse of authority, whether there was inability to escape by the victim, and if there was an absence of free voluntary consent. All this was looked into. And the final conviction obviously gives you a clear indication which way the High Court went. There was another interesting aspect of the entire case. What weight should apology emails carry? Meaning, Tarun Tejpal wrote a lot of emails apologizing for his conduct. The prosecution took those mails and said if he has already accepted that he committed those acts, then that is a confession, and hence that strengthens the case against him. And this was one of the most discussed evidences throughout the case. These emails sent by Tejpal. This was one of the most central aspects of the entire trial. The prosecution treated these emails as highly incriminating. The defense argued that these emails were merely an attempt to preserve an organization, meaning Tehelka, and relationships, rather than admission of criminal guilt. This is what Tarun's lawyers said. And finally, this case examined a very important question. How should courts assess workplace power? How should court assess workplace power and the imbalance that comes out of workplace power? Therefore, this case also raises broader questions, especially in a journalistic workspace between the editor and subordinates, influence of professional hierarchy, possibility of implied coercion, and whether apparent compliance equals consent. These were all major issues that have come up and go beyond just this present case. Therefore, the trial court saw it in favor of the accused. The High Courts overturned this in favor of the victim. The Supreme Court is likely to re-examine all the parameters in a case that has traversed the boundaries of just another criminal rape case. The universe of workplace relationships, the question of coercion in a dominant position, as well as implied consent and established previous relationships, all of this is a tightrope walk between justice and victimization. For writer and author Tarun Tejpal, the last chapter on this story or in this book is yet to be written, but he's at a very important crossroads in his life, convicted of raping his junior employee at that point of time. This landmark case has ended, but yet another landmark case of the same case will begin in the Supreme Court soon. Thank you very much. Thanks for watching INK Goa. I'm Shujoy Gupta.